Hey, Ken, thanks for coming on the program tonight, sir. Great talking to you.
Cam, it's always great to be with you. Thanks.
Yeah, you bet. All right, well, we once again saw Eric Holder on the hot seat today, this time over on the Senate side of the aisle, and Senator John Cornyn, Senator Chuck Grassley, both with some harsh words for the Attorney General. And Eric Holder, appears to be, and I say appears to be, trying to offer an olive branch to the individuals who want these documents turned over. What did you take away from today's hearing?
Well, I think that may be a fair way to characterize it, Cam. I think, though, even though this is in the Senate side, I think that's being driven by the fact that shortly the U.S. House, the other chamber, is going to vote on whether to make him only the second Attorney General in U.S. history to be held in contempt of Congress, something for which a person can be criminally prosecuted. So I don't know if his audience for that was for the senators, because he knows that Harry Reid controls the Senate and Pat Leahy controls that committee, so he's got some friends and supporters there, or if that was instead an effort to give a head fake to House Republicans to get them to cool off on the idea of voting to hold him on contempt for his refusal to comply with the lawful subpoenas that Darrell Iss's committee has put out, requesting tens of thousands of pages of documents on Operation Fast and Furious that Eric Holder refuses to hand over.
Absolutely. And, it seems at this point, Ken, that the defense of Eric Holder, the defense of DOJ is, well, gosh, why would you rush to judgment here? Why are you all in such a hurry to conduct these votes on contempt of Congress? Kind of lost in that is that the subpoena was issued back in October of 2011. There hasn't been a rush to judgment. There has been a failure to comply.
Yeah, I think there's 2 points here, Cam. One is what you just said. This has been hanging out there a long time. This isn't like saying, I am subpoenaing this, and next week I want those 90,000 pages on my desk.
Right.
This is an issue of months and months that this has gone on. I think the second issue, though, is not just the time frame, but due process gives a certain minimum number of days that the recipient has to respond to what the subpoena asks for. Of course, that's gone months, as we just said. But beyond that, it is still a lawful subpoena. So there is no, well, gee, calm down. It hasn't been. It's you're being a little demanding here. Congress can be as demanding as it wants. The law is the law. A House committee has legal authority to subpoena these documents from any agency of government. In this case, it's the House Government Reform and Oversight Committee, whose job it is to investigate executive departments like the Justice Department. So regardless of the excuse, the bottom line is Congress is doing its job here by demanding those documents, and Holder's duty is to comply with that subpoena.
Absolutely. So do you think the Attorney General helped his case at all today?
Well, I think it depends on what his case is. Generically speaking, I would say no,
okay.
because I don't think he heard it at all. But you were seeing some senators, even regarding a separate issue, a national security issue, Senator Lindsey Graham, getting hot under the collar, which is, I think, very uncharacteristic of Senator Graham.
Right.
There are some senators who are pretty hacked off right now, and their collective anger, I think, is only half of what it is on the side of their House counterparts. And I think, again, I don't think Eric Holder is in trouble before the U.S. Senate, but I think he is in real trouble right now before the U.S. House.
Talking with Ken Klukowski, Breitbart legal contributor, and, as you say, over on the House side, obviously it looks like the votes are there to get the contempt of Congress charge out of committee, and you have Representative Issa saying he expects as many as 31 Democrats to join in voting to hold Eric Holder in contempt. And again, for I think the third time now, Speaker Boehner has come out and said, look, there is no daylight. That was the phrase that he used today. There's no daylight between House leadership and Representative Issa. The administration, I think, has been trying to float this narrative out there that there's some sort of wedge between Issa and Boehner, that the House leadership really doesn't want to pursue it. I don't know, how much more forceful John Boehner could be in stating that that's not the case.
I agree with you there. I think they're making it clear that the media may try and paint it that way, but of course, these congressmen are going to decide things together, and they all know what the score is on this. I think the question becomes then, what comes next? The contempt citation comes out of the House committee, goes to the House floor. It passes the House floor. Now Holder is held in contempt. What happens at that point is really the one thing that could legally happen is not going to happen, and that is that under the literal wording of the law, they can actually, the Sergeant of Arms of the U.S. House can go and physically arrest and take into custody a person held in contempt by the House, drag him back to the Capitol, and put them behind bars in a room in the Capitol building. Now, obviously, that's not likely to happen with the Attorney General of the United States,
right.
Even though the law literally allows it. Instead, it is, and courts have said, that would be kind of an unseemly picture for that to happen. Instead, when someone is held in contempt of Congress, the usual process would be for that contempt citation to be referred to the local federal prosecutor, which here would be the U.S. Attorney for the District of Columbia, to prosecute the person, criminally prosecute the person who's been held in contempt, and if they are convicted, to put them in, to take them into federal custody, into the federal prison system. Well, in this case, again, we're talking about the Attorney General, who is, if you have the U.S. Attorney for D.C.,
right.
The Attorney General is his boss's 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 boss. So the U.S. Attorney serves 4 levels down under the Attorney General. You can imagine that the U.S. Attorney in D.C. is not going to be prosecuting his ultimate boss in that regard. So then the question becomes, what recourse does the House have? And the reality is, at that point, the question is, are they willing to take the next step, which would be passing another majority resolution, going again to the House floor, and voting to authorize Darrell Issa to file a lawsuit in federal court in the name of the U.S. House to try and get a court order to require Eric Holder to finally spill the beans on all those documents that he's now withholding.
Okay, let me ask you one final question here, Kim, because Eric Holder repeatedly today talked about trying to avoid a, quote, constitutional crisis. Now, I'm not sure what he meant. I'm guessing this refers to, I don't know, is Eric Holder going to try to assert executive privilege in withholding these documents? Is that what he's referring to?
Well, that is the only option that's available to him legally. If Congress subpoenas information from the executive branch, the only grounds, now if we were talking about the military or something, then there's another defense called the state secrets doctrine. But that doesn't apply here. That only applies to like military secrets and diplomatic secrets on the foreign policy side of things. Here, of course, with the Justice Department, we're talking about law enforcement. We're talking about the death of a Border Patrol agent and the laws that were broken allowing these guns to walk across the border to the Mexican drug cartels. In that regard, the only defense available to him is to say, he is right now saying, I'm kind of complying with the subpoena. I'm doing well enough. But the only way he could say, and the things I have not turned over, I am not required to turn over, is if those documents would be shielded by executive privilege. So he has not used that term yet, and Darrell Issa noted in a letter to him, we are not aware that you are asserting this. So, I mean, Darrell Issa's even put it on the table. Are you invoking executive privilege here?
Right.
That term has not been used, probably because, among other things, it's a loaded term. If you, that's like, it feels like taking the fifth.
Right.
I mean, legally it's completely different, but politically it's the same effect, where people say, oh, what are you trying to hide here? So I think we're eventually going to get to that point, and that, again, would be the issue that a federal judge would have to decide if the House goes the next step and takes this to court, and that's what we should be looking for over the next few months.
All right. Well, listen, Ken, thank you so much for coming on the program tonight. Great talking to you, and look forward to doing this again soon.
Thanks, Cam. Me too.